In the wake of Bruen, states fell into three categories: constitutional carry or permitless carry states, now a majority, required no permit at all. Shall issue states, which make up most of the rest, require a permit but must issue it if the applicant meets objective criteria like a background check and training. Then there were the states like New York, New Jersey, California, Maryland, Massachusetts, and Hawaii that had long operated may-issue systems. After Bruen, these states didn't simply convert to shall issue. Instead, they passed new laws attempting to navigate around the ruling. They replaced proper cause with a web of new, highly restrictive requirements. They expanded lists of sensitive places where carry is forbidden, often including public transit, parks, restaurants that serve alcohol, and any place of public assembly. They implemented extensive training mandates, character reference requirements, in-person interviews, and even liability insurance proposals. The argument from these states was, we're not denying based on subjective cause, we're just setting a very high objective bar. Gun rights groups argued this was Bruen in name only, a de facto denial system dressed in new clothes. This is where the emergency ruling comes in. Multiple lawsuits were filed, arguing that these new state laws were unconstitutional under Bruen. As these cases moved, applicants sought emergency injunctions to stop the laws from being enforced while the litigation continued. The Supreme Court's recent action granted that emergency relief. While the full text of the order is brief, its meaning, interpreted through the lens of Bruen, is thunderous. It signals that the court sees these post-Bruen state laws as likely unconstitutional. It tells lower courts they are misapplying the Bruen test. Most importantly, for residents in these states, it means that the core discretionary denial system, in any form, cannot stand. The pathway to a permit, while still subject to some regulation, must be objective and shall issue in practice, not just theory. It immediately halts enforcement of laws that functionally preserve official discretion, changing the reality on the ground for permit applicants as of today. Let's get practical. What does this mean for you depending on where you live? Scenario 1. You live in a formerly may-issue state, example, New Jersey, Maryland. The emergency ruling is your green light. The state must process your application based on objective criteria. If you meet age requirements, pass a background check, and complete state-mandated training, they shall issue the permit. You no longer need to prove unique hardship. Start gathering information on your state's specific training requirements and application process now. Document every step. If you are denied without a clear, objective reason, like a failed background check, you likely have strong grounds for a lawsuit. Scenario 2. You were previously denied a permit in one of these states. You should consider reapplying immediately. The legal basis for your denial is likely invalidated. Keep records of your previous denial and your new application. Scenario 3. You live in a shall issue or constitutional carry state. This ruling doesn't directly change your daily life, but it strengthens the national legal foundation for your rights. It also may impact reciprocity. As these states change their laws, reciprocity agreements recognizing out-of-state permits may shift. Always check current maps before traveling with a firearm. A crucial warning: this ruling does not create a free-for-all. States can still have permitting processes. They can still mandate safety training. They can still define prohibited persons, felons, those with domestic violence restraining orders. The expansive sensitive place laws are currently being challenged in separate litigation. You must know and follow the specific laws in your state and any state you visit. Ignorance of a no-carry zone is not a legal defense. Do not mistake this emergency ruling as the end of the story. It is the opening of a new chapter. We can expect 3 immediate consequences: a wave of litigation. This ruling emboldens challenges to every aspect of restrictive gun laws. We will see targeted lawsuits against sensitive place lists, arguing they are so broad they nullify the right altogether. Lawsuits will challenge excessive training hours and fees as modern-day proxies for discrimination. The historical analogy test from Bruen will be applied to assault weapon bans and magazine capacity limits. Political backlash and innovation. Legislatures in states affected by this ruling will not sit idle. They will look for new, creative ways to regulate within the bounds the court has set. The political debate will intensify, with fundraising and campaigning centered on this issue. Clarification from lower courts. Federal district and appellate courts now have the unenviable task of applying Bruen's standard and this emergency ruling to each specific state law. This will create a patchwork of decisions that may eventually require more full Supreme Court opinions to resolve. The core principle the court is upholding is that a constitutional right cannot be a privilege granted only to those who convince a government official of their special need. It is a right exercised by default by law-abiding citizens. So what is your responsibility in this changing landscape? Become your own chief of information. Do not rely on gossip or outdated information. Follow reputable legal analysts and official state government websites for permit information. Organizations like the Firearms Policy Coalition, Second Amendment Foundation, and your state-level gun rights groups provide excellent updates. Seek quality training. Regardless of legal requirements, seeking professional, responsible training in firearm safety, handling, and the laws of self-defense is paramount. Your right carries a profound responsibility. Engage civilly and knowledgeably. The debate around the Second Amendment is deeply passionate. Whether you support this ruling or oppose it, engage with the constitutional principles and historical arguments, not just emotions. The American experiment in liberty is built on enumerated rights. The judiciary's role is to guard those rights from infringement by popular majorities or government overreach. This emergency ruling, building on Heller, McDonald, and Bruen, is the latest and one of the sharpest reminders that the Second Amendment is not a second-class right. It is the right that safeguards the ability to defend all others. This is a complex and rapidly evolving area of law. Our goal is to provide clear, accurate information to help you stay informed. If you found this breakdown helpful, please consider subscribing for more in-depth analysis on legal and policy issues. We encourage you to share your thoughtful perspectives in the comments below. What questions do you still have? What are your concerns? Let's keep the conversation constructive. Remember, in a self-governing republic, an informed citizen is the ultimate check and balance. Thank you for watching.